Okay, let's continue. Any questions so far regarding the lecture materials? If no, okay, the final part. Okay, before the break, we talked about acceptance of past performance. But there could also be acceptance or discharge of a contract by agreement. Okay, agreement. So the contracting parties agree to end a contract. This can be done before the original end date. Okay, so the old one becomes extinguished by the new one because the two parties agree to end the contract. Then the agreement becomes a new agreement, extinguishing the old one. Okay, new one. The new contract must contain the essential elements for a valid contract. This A can be deleted, okay, for a valid contract. Okay, so must comply with specific form if so required. Say, as I mentioned earlier, some contracts needs to be in specific forms, like the sale of land, right? So another condition is the new contract must contain the essential elements. So itself, the new contract must be a valid contract containing the essential elements. And if one party, for example, A has performed, but the other party B has not, then what happens? Party A may release B through the new contract. And under a new contract, that new contract can be made by deed. If it is a specific type of contract that needs to be made by deed, or requires B to pay a consideration for releasing himself. Okay, so this could also has the effect of the discharging a contract. And under the new contract, there is accord and satisfaction. This is a very specific phrase. When we have the new contract, okay, when we have the new contract, then there is a accord and satisfaction. So what do these two terms mean? The first one, accord, the agreement by which the original obligation is discharged. That means the original agreement, the obligations will become extinguished. Satisfaction meaning the consideration which makes the new agreement operative. So that in short, we have the new contract in effect, superseding, extinguishing the old contract. Then we have accord and satisfaction. Okay, here I hope you still remember. Let me have a quick look. Okay, yeah. Effects of a contractual term. Now, maybe, okay, let's have a quick visit of our last lecture. Lecture 2. Remember, we have contractual terms. Remember this picture, right? And there are 3 types of contractual terms: conditions, warranties, and acknowledged terms, right? So the breach of any of these 3 types will lead to different results. Okay, if it's condition, if it is warranty or acknowledged term, the effect could be different. So contractual term may prevent a contract from coming into effect. So that is condition precedence before that. Can also bring the contract to an end. Conditions subsequent after. Precedence before, subsequent meaning after. Okay. And a contractual term may also allow the innocent party to terminate the contract. So if it is an essential term, which is critical, if it is breached, then the innocent party may terminate the contract. That is an option to terminate clause. Okay. So you often find in a contract, there is a section or some clauses saying provisions of termination of a contract, under what situation the contract may be terminated. Okay. That relates to this part, option to terminate. Operation of law in certain situations, like for example, where you have two companies and they merge, or one of the parties becomes bankrupt. These are some certain specific situations. So the operation law will discharge a contract. So if you have a contract with a company and that company becomes merged with another company, then by merging, that original company doesn't exist anymore. So by operation of law, that would discharge the contract you made with that company in the past. Okay? Independently of the wishes of the parties, no matter what you wish, right, by operation of law, that would discharge the contract you made with that company, or that company becomes bankrupt. No more, right? Because what the company will not be able to perform anymore. Doctrine of frustration. Remember, we have doctrine of precedent, right? Here we have doctrine of frustration. So what it means is, frustration arises if without fault of either party after formation of contract, but before it is due to perform. Now, this is a very important condition. After you sign the contract, after a contract is formed, but before it is due to be performed, before it is really performed, there occurs some unforeseeable events, or what we call the frustrating events. And the event changes, alters the circumstances, making it impossible to perform the contract. So could you quote an example to help your understanding? Impossible to perform the contract. What situation, what events would cause it impossible to perform a contract? Now, for example, okay, originally you have an FM service to be provided to a particular building, building A, okay, to a particular building A. If, like, unfortunately, if that building got a big fire, for example, right, seriously destroyed, then how can you provide FM service to that building, right? No way. And that is a frustrating event. Impossible to perform the service anymore. All right? So that is, by frustration, that contract would be discharged. Understand? Right? So the contract becomes, another possibility is it becomes radically different from what the parties had contemplated when they made it. It becomes very, very different from the two parties believe it to be. When they sign the contract, they consider the contract should be in a particular way, but now it becomes very, very different. The contract is at an end. The parties shall be relieved from performance. So you can refer to this precedent, Taylor. This is even more common. Breach of the contract. Breach. That means some of the contract terms could not comply with. Now it depends on this seriousness. Seriousness. Okay. May or may not discharge the contract. Why? Because, as I said, it depends on whether the breach is about a condition, a warranty, or a nominal term. So it is this picture. Contractual terms comprises three different subdivided categories: conditions, warranties, and nominal terms. I hope you still remember what they are. If not, do a revision. Okay. Now, if it is a condition is breached, then what? Because condition is a major term in the contract, so it enables the innocent party to regard the contract as discharged. No more. Okay? No more contract. If it is a breach of the warranty comparatively compared with condition is not that important or critical comparatively. Okay. So it does not discharge the contract, can only claim for damages. The innocent party can only claim for damages, but still need to go ahead with the contract. Could not take it as discharge. The contract doesn't end yet. Okay. Breach of innominate right, term. Seriousness of this breach determines if the contract is discharged. It depends on whether the breach is serious. Remember, innominate term is what? This one. Whether contract term is a condition or warranty is determined at the time of making, but in reality, the effect of a breach of a term often realized after the breach. That means we don't know the effect until the term is breached, until we realize the effect after the breach. Okay, so that means we didn't know at the beginning whether this term is so critical or not critical. It's what we call intermediate or innominate term. Innominate term. Okay, then final part, remedies. So take a quick look at, we are talking about damages, okay? Damages. In case of breaches, contract breach, if the condition being breached is serious, if the breach is serious, then the innocent party can elect to treat the contract as discharged, right? May what? Refuse to perform. Say if there's a breach of the contract, originally I have to provide FM service. Now the contract comes to an end. I'm not going to perform. I'm not going to provide the FM service. Okay, this is one possibility. Refuse to perform. Okay. For example, every month the owner has to pay me as a contractor. But this is a term, right? Contractual term. But now the owner stopped the payment. Then I can refuse to perform as a contractor. Okay, because this is a serious breach. And what? Recover any money that he has paid to the party. Now, this is another way. Say if the owner has paid money to the contractor, but the contractor does not provide the service, then the owner can claim the money back, right? Recover any money. Sue the party in default for damages, again any loss or any suffering, okay? As alternative to damages, sue on a quantum merit basis, again this term, reasonable remuneration for the work done or goods supplied, right? To claim the amount, to claim the reasonable amount for the loss. Reasonable remuneration. Now, if the innocent party elects not to treat the contract as discharged, so the choice is on the innocent party. The innocent party can choose whether to treat the contract as discharged or not. Now, if he chooses to treat the contract as discharged, he must perform his outstanding, the remaining contractual obligations. If he fails to do so, he may be held in breach. So this could be dangerous. Okay, so if he fails to perform the outstanding part, the remaining part, he may be held in breach. Although originally the other party is in breach. Okay, but if he stopped doing nothing, then he may be held in breach. Conversely, okay? If the breach is about warranty, the second type, warranty, not conditions. How about warranty is breach? The contract is not discharged. You can't treat the contract as coming to an end. There's still a contract. The innocent party but still bound by the contract and may seek remedies. What you can do is to seek remedies. So what possible remedies? That could be damages, specific performance, and so on. So what are they? Damages, specific performance. Now there are different types or natures of damages. For example, the first type is nominal. Nominal, not normal, okay? Not normal, but nominal. Nominal damages. A very, very small sum of money awarded. Okay, if the loss of the plaintiff is negligible. Say if you made a claim, if you are the innocent party, you claim for the loss, but the loss is really very, very small, negligible, very small, or even none. Okay, he could only prove the loss he claims. But you want to win the case so that you have the grounds, you are really the innocent party, right? But actually what you can claim back from the judgment for winning the case is just very minimal, very negligible. Just to recognize that, oh, okay, you are really the innocent. Okay, you can refer to this case as the precedent. This one is more common. Ordinary or compensatory damages normally awarded. So this is the actual amount of your loss. Say in a contract, due to the breach of the other party, you lost $10,000, for example. Then you claim it back, 10,000 Hong Kong dollars. Okay? It's not supposed to be, say, oh, you lost 10,000 Hong Kong dollars, then you want to get back 50,000 Hong Kong dollars. No. Okay? The amount to be compensated is the amount, exact amount of your loss. Okay, that's the principle. Exemplary damages, also known as punitive or vindictive damages. So, meaning what? These amount of damages usually is awarded to punish the party in breach. Now, but it had been abolished, but still applicable in some specific cases, in tort cases, which we will talk about later. But because what? Because in contracts, the principle is the amount of damages should be the amount to cover the loss. Should not be something unreasonably more or unreasonably less. Okay? As I said, if you lost 10,000, you will be compensated 10,000. That's it. Okay? That is to be fair, not to punish. Okay? That's why LD, I think this term is very common. If you have been working in the industry, you may have come across this term. Construction project, delay of the contractor, then the contractor has to pay LD, right? Liquidated damages. Okay. It's a common clause in standard forms of construction contracts, but often not properly incorporated in contract. Now, although you may have come across many, many contracts with clauses saying, okay, liquidated damages in case of delay, contractor has to pay, say, okay, 10,000 per day, 100,000 per day, or even 1 million per day, right? They are there, but the amount sometimes are unreasonably high. So you can state whatever you like as the client, say in the contract, and sometimes the contractor has no choice but to sign the contract. Say a delay per day, you can state 1 billion. Okay, but the actual loss or due to the delay for 1 day, is it really 1 billion? It may be just 1 million. Then 1 billion is unreasonably high, right? Which is not fair. So as if a penalty rather than compensation in that case, if you state 1 billion in the contract as the LD rate. So in contract law, LD should be a genuine, real pre-estimate of actual loss. Penalty is for punishment purpose, therefore not enforceable. Okay, you may state, the client may state a very, very high level of punishment, LD, in the contract, but in the end, it could be not enforceable. Okay, because what? LD should be a genuine pre-estimate. Say if the delay for 1 day is 1 million, then you should stay 1 million, not 2 million, 3 million, or 1 billion. We have LD, we also have unliquidated damages. The amount not predetermined. That means at the beginning, we did not estimate, we are not fully confident or clear about the amount of loss. And the amount is to be assessed by the court based on the actual loss after the breach. And there could be other remedies, like other than damages, there could be other equitable remedies awarded at the discretion of the court. Now, this is something sometimes people feel dissatisfied or do not like. Because whenever it comes to discretion, some may have the feeling that, well, it is decided by somebody without any strict formulas or rules. Okay? But sometimes these are useful because in some specific situations, we could not follow some rigid rules to do so. These are specific performance, injunction, and rescission. So what is specific performance? And what is injunction? And also, what is rescission? Now, for these 3 items, I would like you to do some reading, okay, to help your understanding. I would explain them to you later, okay? But I would like you to do some mini homework, read and try to understand what they mean. Specific performance, injunction, rescission. Final one I explained already, quantum merits, but you can also take a look further on what they mean. Here are the references. Contract law, more or less same as those I listed in the previous 2 sets of PowerPoint slides. Okay, so I don't need to repeat them anymore. All right, so now if you have checked the timetable, you should be aware that I put here also mandatory maintenance of building works in case we have sufficient time. But, okay, silent, okay, silent. So now I will reserve it to be maybe covered in a later lecture somewhere here or here, okay? Because what? Because next week, next lecture, I will start talking about tort law for FM. That will be the first lecture. And then after the New Year break, the second lecture on tort law, and also the third one, partly on tort law and also building management matters, will be by William. Okay. Then when we come back, I will talk about this one, mandatory maintenance of building works. Okay. Okay. Any questions? No? Okay. Thanks for coming. Okay. See you next time.